During his imprisonment, he earned a master's degree from New York Theological Seminary. Hayes was paroled in 1991 and since then has become a noted spokesman against the death penalty. What you should also know about Lawrence Hayes is that he's been a very fearless activist in terms of abolition of the death penalty. More specifically, there's not been one event, one meeting, one discussion that I've been a part of in New York, in different parts of the country that I know Lawrence Hayes was not at. And so he's really been a hero of the people. So that's Lawrence Hayes. And to the left of Lawrence Hayes is Tanya Green. Tanya Green currently serves as National ACLU Advocacy and Political Counsel. Her state and national work focuses on criminal justice issues, including the death penalty, indigenous defense, solitary confinement, and juvenile justice. Previously, for almost 15 years, Ms. Green represented indigent capital defendants in New York State and in the Deep South, and consulted with and trained capital defense practitioners around the country, and we're very happy to have Ms. Green here today. So we're going to start this discussion in a particular kind of way. We're going to start off with Tanya Green. You've all just seen the film about Reggie's case. But for many of you that know, this event is called A Broken System, from Troy Davis to Reggie Clemons. We know that the United States of America has racial injustice throughout it. And so you can't talk about the death penalty, you can't talk about the criminal justice system without talking about racial bias. And so she's going to talk to that for the next 5 minutes, and then we're going to hear from our other speakers. Is that all right with y'all?
Yes.
Very good.
All right, thank you. I appreciate the invitation to join you today, and I'm going to try to do 5 minutes, and I guess somebody's going to throw something at me if I go over. Because I have a lot to say. You know, this system is fraught with problems. Race, poverty, innocence, prosecutorial misconduct, jury selection problems, judge crookedness problems, the inhumanity and immorality of the death penalty. All of it all comes together. And in a case like Reggie Clemons is, you have a lot of examples of a lot of what's wrong with the system, just like you have in the Troy Davis case. So today I want to talk a little bit about the legal process, so I want to set it up for folks who don't necessarily know how things happen. And then I'll talk a little bit more about false confessions and some of the issues that have come up in Reggie's case. I'm happy to answer questions at the end about whatever legal stuff y'all need to know to help clarify the situation and be helpful to folks. So I provided a handout with some basic information about the death penalty. If you didn't get a copy of it, there should be more on the back in the back of the room. 34 states right now have the death penalty plus the federal government and the U.S. military. That's actually down by 4 in the past 7 years. We've been making progress. It doesn't necessarily feel like it in some states, but New York, New Jersey, New Mexico, and Illinois have gotten rid of the death penalty in the past 7 years. And so that's definitely progress for folks. At this point, we have 16 states without the death penalty. There are approximately 3,200 people on death row, including about 63 women, which is an interesting number because that number in the past 10 years has doubled. The women on death row. Okay, prior to 1972, there was little, if any, central control over the death penalty in the United States. States did what they wanted, to whom they wanted. You could get the death penalty without having killed somebody. You could get the death penalty for one crime and not another crime, even though they're very similar crimes. Blacks received the death penalty across the South for crimes that were only fined if you're a white person and having committed the same kind of crime. In 1972, the U.S. Supreme Court decided to change all that and make a little bit more consistent system through its decision in Furman v. Georgia. And it charged all the states that wanted to have the death penalty to develop state statutes that balanced what they called guided discretion, which is kind of like the rules of the death penalty, with individualized consideration, which is consideration for the particular circumstances of the crime, the circumstances of the defendant, to make a decision about whether or not he deserved the death penalty. In 1972, when Furman was decided, as a signal of defiance in opposition to the ruling, I always think this is interesting, a judge in Florida slung a noose over the courthouse tree, the tree in front of the courthouse, harkening back to simpler times where we could just get what we needed done. And so it's clear that, from the very beginning, and if you know much history of this country, you know about lynching, you know about the Black Codes. There's a really great film that just came out called Worse Than Slavery that I encourage y'all all to read, to watch. It's the book that it's based on, about the legacy of government control of Black people, social control of Black people, particularly Black people, poor people, by the criminal justice system. And the death penalty is like the pinnacle, I would say, of that attempt at control. In 1976, the Supreme Court reviewed 5 new statutes, new death penalty statutes. North Carolina and Louisiana statutes failed because they were mandatory schemes. So it was decided in 1976 forward, and that hasn't changed yet, other than as the Supreme Court, we always risk this, that you can't automatically get the death penalty for anything. You have to have that balance. You have to have the rules, the guided discretion about what categories of crimes fit the death penalty, balanced with the individualized determination. Texas, Georgia, and Florida passed with flying colors. They each have 3 different systems, but they balanced enough for the Supreme Court, at least, to allow the death penalty to go forward. And since then, after that, 35 states then passed more death penalty statutes. And since that's changed a little bit with the 4 that I told you recently abolished. And in 1977, states started executing again. And since 1977, there have been more than 1,200 executions in this country. Okay, then a little bit more about the system. A capital trial is bifurcated, meaning there's a jury that's selected to review the case, but the case is reviewed in 2 stages. There's the merits phase, which is the guilt or innocence phase, and then if the person is found guilty of capital murder, there's a penalty phase, where the jury then decides whether or not the person lives or dies. In some states, the jury decision is final, and in other states, the judge takes that jury decision under consideration and doesn't have to stick with it. And that those states are called override states, and there are only a few of them. Alabama is the most famous. 25% of the guys on death row in Alabama are there as a result of a judge override of a jury sentence of life. So 12 people were convinced that he deserved to live. But the judge said, and there's no standards that the judge has to adhere to. They don't have to give a reason. I don't think he's gonna, I think he should be executed, and so he would. The individualized consideration, for the most part, is referred to as mitigation evidence, and that's usually involves a social history investigation of a defendant, and it is every defense attorney's responsibility to investigate the history of the client and put an argument forward about why he should live instead of die during the penalty phase. You all who may have been following the death penalty will know that we've made some progress also in certain categories of death-eligible cases. For instance, in 2002, in the Atkins v. Virginia case, the Supreme Court found that the mentally retarded or intellectually disabled cannot be executed. Now, they told all the states, y'all decide how you define mentally retarded. And so a lot of states have a beyond a reasonable doubt standard to prove that you're mentally retarded. And if any of you all have mentally retarded or intellectually disabled people in your life, you know that they spend the majority of their time trying to convince people nothing's wrong, and so there won't be evidence, and it'll be very difficult to prove. And here, where it's a matter of life and death, we have situations where a client in Georgia said to a former colleague of mine, after the IQ testing, I did my best, I tried my best, and he actually got above 65 during that testing, and he was executed because he did so well. And so, people who don't even understand what's going on are put, to this kind of test. And then in 2005, in the Roper decision, juveniles were finally exempted from the death penalty. That children under 18, when the crime was committed, could not be sentenced to death. I want to do some quick race numbers. I know I'm probably over 5 minutes already, right? I'm sorry. Okay, so some quick race numbers because I think that that's important to keep track of. Over 75% of the murder victims in cases where the defendant was executed are white. Over 75% of the murder victims in execution cases are white. Nationally, only 50% of murder victims are white. So you can see the skew there already. In the death penalty system, 35% of those executed were black. 56% of those executed are white. The U.S. is 12% black and 75% white. The federal government authorized seeking the death penalty against 74% so far. And when we look we look to the states and we're like, oh man, the state's out of control, this is South, and the legacy of racism, so the Fed has got to get it right, right? So this is supposed to be the highest standard of practice, and still in the federal government system, you have 74% of the people sought, who the death penalty is sought after being people of color. And despite what TV cop shows would have us believe, most murders are intra-racial, white on white or black on black. And the fears that whites have that blacks are more likely to kill them than kill other blacks is inaccurate and unfounded, and we have proof of that from the federal government itself, per the Department of Justice, Bureau of Justice Statistics. Studies from 1976 to 2005, 86% of white victims were killed by whites, 94% of black victims were killed by blacks. But blacks and whites are murder victims in almost equal numbers of crimes, though, which is a terrifying percentage when we think about the population statistics. African Americans are 6 times as likely as white Americans to die at the hand of a murderer. Young black men are 15 times as likely to be murdered as young white men. So we have some jobs to do. I want to quickly go to a discussion of coerced confessions and false confessions, because we have that in Reggie's case, and then we can go back to some discussion about judges and juries and prosecutors if y'all want to. Oh, one other thing I did just want to say about prosecutors. The decision to seek the death penalty is purely a prosecutorial decision. There's a lot of 0 minutes left. There's a lot of law enforcement decision making that goes into it, like what cases get investigated, what cases get a lot of media attention. But ultimately, the prosecutor is the final decider. And I just want to point to the fact that 98% of the prosecutors across the country are white, and so that certainly has something to do with decision making. So 10 main categories of false confession. Some of the highlight ones include brainwashing, deceitful persuasion that convinces someone he's committed the crime, desperation. The accused is desperate to get the interrogation to end, so he just confesses, which sounds like what might have happened in Reggie's case, where he said, okay, fine, I did it. No, I didn't, realizing that he was saying what he was saying. Inquisition, the only way to avoid the death penalty or another harsh measure is to confess, which is what his co-defendant sounded like happened. Mental fragility, inference, fabrication, opportunism, subject to secondary gain, and then police force, coercion. I'm going to leave the rest for questions, and I apologize for running through stuff as I need to, but hopefully that sets the stage for you and what we can talk about tonight.
We definitely have more time for questions, where we hope that you guys can kind of get all those burning thoughts that you need to get answered and addressed. We actually also have scheduled Reggie to call in, which is why we're a bit short on time. So I'm going to pass it off to Lawrence Hayes to talk a bit about his experience, but also talking through what's the connection between Troy Davis and Reggie Clemons.
Oh, briefly. In 1971, I, as a member of the Black Panther Party, involved in trying to get drugs out of my community. I got involved in an incident which resulted in one of my comrades being shot. And one of off-duty New York City police officers being shot. I was tried. I was caught at the Canadian border 2 weeks later, and I was taken to a state trooper barracks in Plattsburgh, New York. I was beaten, and the next thing you know, I came out of that 2 days later from a plane at the LaGuardia airport. They're saying I confessed to something. Next thing you know, I had all-white jury, all-male, that was jury 55 out of Queens County. I was convicted and sentenced to death. A year after I was in the death house, the prosecutor in my case was disbarred for taking bribes from organized criminals, and we were raiding organized criminal drop spots. A year and a half after I was in prison, the judge in my case was citing a New Yorker magazine article by Jack Newman as being one of the 10 worst judges in New York State because of his favoritism of organized criminals. And it was later learned that the lawyer who represented me was a lawyer who frequently organized crime clients. But that didn't get me out. wind up getting out because Phony versus George, I got out of the death house, and then basically on my own conduct, I was released on my first parole board. So, I mean, I studied law while I was in prison. I actually earned a paralegal degree from Bronx Community College. And this is, this is my take. The Troy Davis case was a travesty of justice. The case was based purely on witness testimony. You had 70 witnesses recant. To us, why isn't Troy Davis here with us today? The old lynch mentality. He did it, we know he did it, and we're going to kill him. And no matter what nobody do, we're going to kill him. There were some issues in the Troy Davis case that I'm concerned with now with the Reggie Clemons case. And I will point to the Sixth Amendment. The Sixth Amendment is the right to have the witnesses against you, to confront the witnesses against you. Evidence is witnesses. In the Troy Davis case, Troy wasn't able to obtain a lot of the DD-5s, a lot of the investigative documents that was done during the initial investigative stages. His lawyers prosecuted the case all the way, but because of the anti-terrorist ineffective, and Effective Death Penalty Act, which was signed in Clinton, he was barred from bringing that issue back up. My understanding is, in the Reggie Clemons case, a rape kit was found. How many years later? 20 years later, a rape kit was discovered. Now, in the Troy Davis case, Troy was granted a very unusual hearing, an innocence hearing. And the judge in the case brought in probably the most difficult evidentiary standard that exists in this country's jurisprudence. And he basically took over everything and ruled on everything. I got problems with lawyers and how they approach the law. I'm telling you straight up and down. I do not, there are some statistics that indicate that something like 85% of the lawyers in our court system are incompetent. But anyway, in the Troy Davis, in the Reggie Clemons case, understand that a lawyer, a group of evidence was never presented to the jury. And therefore, the jury could not rule upon how that evidence would affect the rulings in this case, or their judgment in this case. There was a United States Supreme Court case called Brady, which covered all of that. And based upon Brady, it's called Brady material. Based upon Brady, Reggie Clemons is definitely supposed to get a new hearing, a new trial. And that goes to connect it to another case called Wong Song. The Wong Song case is fruit of the poisonous tree. It says that if anything that happened in the beginning, at the root of the case, means that the entire case is poisonous, and you need to throw it out. You see, so I'm concerned about this new hearing that Reggie is supposed to be obtaining, because the judge now is supposed to be ruling on what the absence of that rape kit and other things, but mainly the absence of that rape kit means, whether it was so significant as to warrant a new trial. However, last but not least, there are other cases that indicate that a judge cannot substitute his opinion for a jury. That's why we have a jury. The jury is our peers, and they are supposed to represent us and be our judges, not the judge. The judge handles the law. And so obviously, the judge in this particular case, I've heard he's a good judge. I heard he has a reputation, but they said the same thing about Mr. Williams. But I mean, we need to understand these things. We need to understand. We need to go back and look at, you know, what's the meat of our system of jurisprudence. And having said that, I'll pass it.
And so now we're going to hear from Ms. Thomas on the specifics around Reggie's case and also the need for us to organize.
Thank you very much. And after hearing some of the things that you said previously, there are far too many issues in the death penalty. And like Lawrence was saying, you have to be concerned about just going through the motion and the final outcome meaning justice or not meaning justice. Because in our case got rubber stamped from the beginning all the way up until where we are now. Basically starting with police brutality was one thing, the forced confession was another issue. But the incompetent attorney not reserving anything made the fight that much harder, caused us to lose issues that we could not reserve. So there is definitely concern that that will not happen again. Because Reggie almost got executed in 2009, June 17th. This is the first time that we've ever been heard in 20 years to any extent at all. You all saw the case started out, chain of rock case, initially April 4th, 1991, when this nightmare started unfolding. And it's still a nightmare. I mean, I often think about all the victims in the case. So there were lives lost, hurt, pain, a lot of that. But we're trying to bring justice to the whole issue. Not just our issues, but people with other issues also. Because if justice can't prevail, like in this case, where can it prevail for any of us? And it shouldn't be all about money, even though we know that it is most times. Money and politics, all of those things, race, all of those things, all the wrong things that keep us from getting a fair trial. We have truly not had a fair trial in the Reggie case. We started out from the beginning being subpoenaed by the prosecutor at the grand jury. So we had to hire an attorney just to be able to take the Fifth Amendment. Luckily, we found out that we were able to do this, and this is something we could do. Otherwise, you'll find yourself testifying against your own loved one in trial with a prosecutor like the one that we had. Every trick in the book, he was tried from A to Z. Then the police brutality issues, where Reggie was told that he would be coming back home with everything paying out. Well, I don't think they were planning on him coming back home. From the time they took him from my house and he was beaten, 2-3 days later in court, his face was still swollen. So this took place on a Sunday. You can imagine how he looked. And by Tuesday, it was still swollen there. Plus the fact that there are reports from the hospital showing that there was an impact blow to his face. However, when we presented this to the trial judge, that Reggie had been beaten, Reggie even told the judge what had happened to him. And the judge decided that this was something the jury didn't need to hear. So he suppressed it. The jury never heard that he had been beaten. So that's one of the issues that I feel that helped cause the jury to give him the death sentence. The other issue in the case was that the prosecutor would help evidence about rape, robbery. He argued it during the trial. The jury heard all of this during almost 2.5 weeks of trial. But what he did not tell was that after the trial, my son received documents from the prosecutor saying that the charges had been dismissed because they hadn't been proven, but the jury never knew that. So there's at least 2 instances of things that the jury didn't know during the trial that I feel would have made a difference, perhaps in their decision. Then we have the, I think it's Reggie on the phone.
This is Reggie.
So what we have now is Reggie has called in to say a few words to us in New York. We're going to try our best. Obviously, he's on the phone, and we have the mic to the phone. But what I like to do is a little chanting whenever we have this sort of thing where someone's calling in, particularly in a case like Reggie Clemons. When I say Reggie, you say Clemons. Reggie? Clemons. Let's try this a little better. When I say Reggie, you say Clemons. Reggie? Clemons. Reggie? Clemons. Reggie? Clemons. When I say Reggie, you say Clemons. Reggie? Clemons. Reggie? Clemons. Reggie? Clemons. Good job. Hello, Reggie. Can you hear us? Did y'all hear that?
Yes.
All right. Reggie, it's a privilege to have you on the phone. What you should know is that I'm here with representing Amnesty International, joined by your amazing mother, Ms. Mary Lee Thomas, Tanya Green from the ACLU, and Lawrence Hayes, and we're joined by people in New York City that want to sit here and learn about your story, Reggie, and how we could support you and be behind you for as long as it takes. What would you like us to know right now, here all the way in New York City, about who you are, about your case, and about what we need to do to support you? Well, thank you, Reggie. And before we leave you, are there any final words that you'd like to say to folks?